right, welcome to the House Judiciary Committee this Wednesday afternoon, May 20th, and we're looking again at H578, the Senate changes to the bill that we sent over there, and we want to hear from Lisa Mylott. If you could identify yourself for the record and tell us, kind of walk us through the highlights or the points that you'd like to, issues you'd like to point out for us, and then we'll see if we have any questions. And you're on mute, so.
You would think I would be better at this by now, but Lisa Mylott, Director of Animal Welfare, and thank you for having me back. It's been an interesting ride since I've last seen you all, with learning a lot more about the legislative process. So I'm happy to be back here with the bill. So H578 started in your committee, and I think that as it went over to the Senate, it was a really strong bill and made some important improvements to the processes concerning animal cruelty. And I think that the Senate Judiciary did a good job of then refining a couple of points that either were a little bit ambiguous or that had been raised kind of late in the day, and both by myself, but then also by the state veterinarian and a few other folks. And so I'm going to walk through primarily addressing the points I heard you asking Hillary about earlier, and just sort of give a little bit more context. The points you all had questions on, I think, are the main points in the bill that were revised. And so happy to answer any questions after that about any of the provisions. So one of the questions that was raised was whether the Director of Animal Welfare should be included as a humane officer, and who a humane officer currently is. There's a couple places in the bill that say that a humane officer or the Director of Animal Welfare can, for example, conduct inspections that are ordered by a court. So right now, humane officer is defined primarily as law enforcement officers. So it's the people who are authorized to investigate the crime of animal cruelty. It could include animal control officers who work for police or other law enforcement agencies, and it can include people in my division. For both the animal control officers and the folks in my division, though, there would need to be training before they qualify as a humane officer, training in criminal investigations. Right now, that training does not exist. I anticipate getting that up and running, but it's not currently in place. So I think it's appropriate to have both humane officer and the director listed, if you're comfortable with that, just because it both gives that ability for me to be involved in inspections now, and it also allows for me to be involved in inspections even if I don't get trained as a criminal investigator myself. My background is as a lawyer, not as law enforcement, so I think that I might not ultimately be the best investigator for these crimes. But that's sort of the bigger picture of what's going on with humane officer and why Director of Animal Welfare is added into some of the provisions. Then the next point that there was some discussion about was the notice provision for where an animal is seized on suspicion of animal cruelty. As you know, we talked quite a bit about how the tension between having the clock run quickly while still making sure that an owner has his due process protections protected. How do we balance making sure animals aren't held longer than they have to be when they're seized, with making sure that people's rights are protected as well? And coming out of this committee, the process was that if an owner was present, he would be notified personally of the seizure. And if the owner was not present, then the notice of the seizure would be tacked. What this adds is a third form of notice, just to try and be as encompassing as possible. So owner who's present is notified personally. The notice of seizure is tacked so that if there is an owner who's not present, so as you all brought up, for example, where there's a couple who co-owns an animal ownership is a lot of times kind of hard to parse because there aren't necessarily title documents associated with it. And so we're saying we just want to give notice to everyone as quickly as possible and try and make sure that everything moves along. So so the Senate Judiciary came down on the end of personal notice that the person's there, tacking it regardless, so that if there's another household member or something like that who might be considered an owner, they're getting that notice as well. And then if there's a known owner who is not physically present, law enforcement, the humane officers have 96 hours or 4 days to take reasonable efforts to notify them. So that's the portion that's been added on, is trying to give them personal notice or notice by mail, if there's a known owner who isn't present. And apparently this is called nail and mail, where you have both the TAC order and you try and reach the person personally. It's called nail and mail service. Eric let me know that after we discussed this possibility. And so the idea is that with the 96 hours, it gives some time. If the post offices are closed, for example, there's still time to try and send that notice out. So if the person's out of state, or if the person has a known address somewhere else, or the law enforcement officer can go and try and make personal service, but they have to do something that shows that they are actually trying to serve a known owner who is not there, to give them notice of the initial time period running and of their rights to ask for a hearing. But the idea was once again, just to try and get as many forms of service going as quickly as possible.
Okay, that sounds good. Appreciate that.
Sure. Then the next provision was with respect to whether these hearings for civil forfeiture should be in civil or criminal court. And in some ways, it makes sense to have them in civil court. And I think that one of your witnesses in committee had suggested that they should be moved from criminal court to civil court, because they are technically civil actions. But forfeitures that are linked to criminal cases actually generally go ahead in criminal court. So for example, car forfeitures with DUIs are heard in criminal court. Asset forfeiture in connection with drug seizures are heard in criminal court, even though those are both civil processes. And when Kim McManus reached out to the state's attorneys to find out if they had thoughts on this, with the idea being, will it go faster if it's in civil court? Will it help alleviate some of the burden of the criminal courts if we move it to civil courts? I believe it was 13 of the 14 essays came back and said that they felt strongly that the cases should be heard in criminal courts, that they will move along more quickly, and that frankly, the essay's expertise is in criminal procedure and in how the criminal courts work. And it would be a significantly higher burden on the essays if they had to then learn all of the processes and everything for civil court for these cases that are linked so closely to the criminal case anyway. So that was that change back to criminal that is reflected in your current draft.
Great. Okay.
Another question was about the payment of costs. So where there is a security paid in and the Humane Society or rescue group is incurring costs. They're feeding the animal that's been seized. They are paying veterinary bills, things like that. There's a cap on what they can get from the Animal Welfare Fund in terms of reimbursement of their costs, and that's the amount that was paid in as a security. And the reason for that is that right now, the only amounts that go into the Animal Welfare Fund is a $2 surcharge per dog license. There actually aren't any surcharges on criminal cases or anything that go in there. It's just a $2 surcharge per dog license. And that surcharge was added on specifically to fund my position. And so right now, the funding from those $2 per dog license is about $30,000 a year less than my salary, benefits, and expenses. So DPS is already picking that up, that excess. If more could be paid out of the fund than went in for the security, it would further deplete the amounts that are available to pay for my position. So at some point, I would love it if we get donations, if we get grants, if we get some stream of income that could provide amounts above the security to reimburse the rescues and shelters. We just are not quite there as in terms of the funds available. So that's what's going on with the Animal Welfare Fund and why amounts being paid out for food and medical care are capped at the amount that goes in through the security. And as Hillary mentioned, at the end of it all, there can be a cost of care calculation done by the court and said, hey, this much went in as security. This was the actual cost of care. Defendant, you need to pay the difference. But that's after considering the total cost. That's after considering the defendant's ability to pay, things like that. And so there is a makeup on the other end that can help reimburse those rescues and shelters. It just would not be coming out along the way from the Animal Welfare Fund.
So I'm curious about the how we know that people are licensing their dogs. One, is there any kind of policing of that? And I think Burlington just started, or some towns have started cat licenses. So I'm wondering if you're getting money from those as well.
So town clerks, select boards are the ones that enforce the dog licensing. Title 20 in general, which is the title that the dog licensing is enforced by select boards. And so it's actually by their animal control officers and constables and things like that. But there is no state level enforcement of dog licensing. With respect to the cat licensing that Burlington has and that perhaps other areas have, no, the state does not receive any portion of those. Those are purely a local fee that people are paying. There was a suggestion in H 841 as it was originally drafted, which is also being heard this legislative session, to have cat licensing statewide, based on testimony. I guess it was House Government Operations removed that from the original bill. And so that portion is not moving ahead.
Okay, thank you.
Sure.
Yeah.
Yeah, Lisa, you may have said, how short is the fund every year? I'm sure it's different every year, but and how much will this bill affect it?
So the fund right now is $30,000 short. There was a little bit accumulated because H626 went into effect with that $2 surcharge a year before I started working for the Division of Animal Welfare. So there was a year's worth of excess funds built up in there that are now being paid down. So it's $30,000 a year short. Right now, it's covered. Fairly soon, it will not be covered. And this bill will not affect it at all because the only amounts being paid out of the Animal Welfare Fund under this bill are the amounts that come in as a security to the Animal Welfare Fund. And those numbers at the end of each case will be a wash because either it'll be paid to the rescue or shelter. If for some reason the amount that a defendant paid in as a security is in excess of the actual cost of care, the defendant would get those amounts back. And so at the end of the day, this bill will not affect the funds overall because of those caps that are written into the bill.
Right, and the people who own these animals that have them taken away, is there any way to estimate how much these people actually pay in? I'm gonna guess a lot of them probably just walk away.
My understanding is that very little of the costs of care are actually reimbursed. That in almost all cases, the amounts that they owe end up being waived. There have been a couple of cases that have had fairly large amounts where there have been a number of animals that might have had medical care. There was one case I read where I think the total amount that was assessed was about $30,000, but my understanding is in most cases, no amount is actually paid in.
Whose decision is it to waive the amount?
The judge. So, both under this bill and under existing
The
law.
judge that it doesn't affect. Just my opinion.
Ultimately, it's the rescues, the shelters, and the towns that end up bearing
Sure.
these costs.
Thank you.
Sure.
I
Go
can't
ahead.
help but say it's almost typical of the Vermont justice system.
Honestly, one of the things I found recently is one of the cases I was just involved in, there were 13 dogs that were seized in January for inadequate shelter. They're small, short-haired dogs that were outside during those Arctic storms we had back in January where the weather was getting down, -20 and things like that. They didn't have any insulation or heating source. They were seized. The shelters that took responsibility for those animals offered to waive any restitution request if the owner surrendered the dogs as part of the process. The owner refused, and now we're 4 months later. There's a plea agreement to where the dogs are being forfeited, and the total restitution request is $36,000. Could have all been avoided back in January. We don't know where the judge will come down on that restitution request, though.
Right. Thank you.
Sure.
Yeah, Ken.
So just for clarification, the dogs were never taken? Never been there the whole
No.
time?
No, those dogs were seized.
Oh, they were?
Yeah, it was sort of I was very grateful to the shelters for working with me on this. It was sort of let's see how this goes. Let's see how quickly we can accomplish things under current law, with filing the request for forfeiture very quickly. Basically, as soon as the evidence was in, with having things supposedly scheduled on the schedule that is set by statute. Turned out some of those moved along fairly quickly, but the final point was between the scheduling conference that they have to schedule the actual hearing and the date the hearing is scheduled. It's supposed to be 21 days by statute, and in fact, that was a 2.5-month period.
So the dogs were taken. Why was the fine so much if the dogs were taken?
Because the owner refused to surrender them, so he is responsible for their vet care and their boarding costs between seizure and disposition.
Gotcha. Thank you. Well, and just for the record, I'm glad the dogs were taken.
Thanks.
Okay.
Okay, then the next point I was going to cover is that there are, I believe, 2 places that provide for forfeiture of title if a person owes funds, if a court says, yes, you owe this amount, and the person refuses to pay. So these aren't cases where the person is asking for a waiver or has been granted one. It's when a court says, this is the amount you actually owe. There are 2 places in the bill that after a hearing before a judge, if the person is ordered to pay an amount and they do not pay within a reasonable period of time, title gets forfeited. And this is because otherwise no one will ever pay those court-ordered amounts. If you can just not pay for 2 weeks and get your animal back, then no rational person will ever pay the court-ordered amounts. And so where the animal is seized, where the seizure is found to have been lawful, the person is told you can have your animal back if you pay the cost of care. And this is the cost of care that the court determines. And like I said, a lot of times it's waived or it's reduced significantly, but where a court orders some amount and the person doesn't pay, this bill now provides that that title be forfeited. And that was a point that I raised. I raised it minimally on the final day in your committee when you were at the point where that needed to be voted out or it needed to be left on the wall. And so Chair Lalonde asked me to explain to the chair of the Senate Judiciary Committee what that point I was making was. And so the Senate Judiciary Committee considered it and said, yeah, if there's not probable cause for having seized the animal, the person gets the animal back without paying additional funds. There's no question about that. And if the person is found to have committed cruelty so that they're losing title, then they owe the costs of care. The question was the gap between probable cause seizure and preponderance of the evidence found that the person committed cruelty, and where the person is ordered to pay the cost of care to get their animal back, what happens if they don't pay it? And so Senate Judiciary considered it, and they agreed that in those 2 instances, because there had already been a hearing and there was a judicial determination of the amount due, that in those cases, they would follow what I believe it's 40 states do. There are no states that do something different, but the 40 states that have addressed it have all found that in that case where there is an amount due, title should be forfeited if the person in fact does not pay it.
Yeah.
And then with respect to the security amounts, as you know, there are some security amounts now set in the bill, and this was based on a suggestion also from the last day your committee had this, to have session law so that there would be some amounts that were set for that initial security until, at that point we were talking about rules being adopted. Now it's until legislation is adopted setting those amounts. And so the amounts in the bill are, I have to say, they're sort of back of the envelope calculations that are intended to be low because we don't want to overshoot, set something in statute that is really unreasonably high and not supportable. So the $1 per day for food for non-livestock, so that means domestic pet type animals as well as poultry, is just a rough approximation. If you look across a variety of animals, some of them will cost much more per day. And in general, animals being seized for cruelty often have special nutritional needs so that their food expenses are higher than what your typical owned animal food expense might be, because they need a special diet, they need supplements. A lot of them have had nutritional deficiencies for a while. So this number, the $1, is I think it's low for those animals. At the same time, I think as an initial security amount, it's okay if it's low, and it's even more okay if it's low, because this is the session law, and I didn't go out and collect a lot of data before. This was a request by Senate Judiciary that I come up with numbers and turn them around really quickly so that we would have something. And so $1 per day for non-livestock animals, and then the $250 if there is a vet appointment needed for treatment of a health problem. And so that doesn't mean the owner has to put in a security amount for the evidence collection vet costs, or for the, let's just have the animal looked over so we have a baseline. It's if there are clear needs, and for non-livestock, $250 is just very roughly just the cost of walking in the door on an emergency basis. It's not going to be the cost of treatment or anything like that, in part because those costs are going to vary dramatically. There's a big difference between, broken teeth and a broken leg and open wounds. All of those things are going to cost very, very different amounts. And so it's hard to say what those could be. Again, with respect to the amount that's baked into this bill as session law, I think that it makes sense. And Hillary had suggested also that it be on the lower end so that it's not greater than what would eventually become the law. And so $250 is just really the cost of walking in the door for a typical vet on an emergency basis. And then on the livestock side, it's also just very much rule of thumb. Livestock animals in general are larger and consume more than domestic pets, and so their cost of food is higher. And the cost of an initial vet appointment, once again, if on an emergency basis, is higher than for your domestic pets. So those are set at $250 per day for livestock animals, and $500 if the animal needs to see a vet for its health. This does not include all exigent circumstances seizures. I know that was a question raised this morning. There are times where an animal needs to be seized for exigent circumstances because there's an immediate danger to its health, but seizing it removes it from that circumstance. So one thing I encountered in Georgia was dogs that had been tethered out and they jumped off a balcony, for example. So they were hanging. That dog needed to be released from the tether to save its life. But it doesn't actually necessarily need immediate vet care, because as soon as you remove that tether, that circumstance is past. And so in a circumstance like that, under the law, the animal does need to go see a vet, because that's one of the, because it's required if you're seizing for exigent circumstances. But that's not necessarily for treatment. That's about evidence, and that's about compliance with the law on the seizing agency side. So I don't know that every time an animal is seized for exigent circumstances that there will be this $250 or $500 necessary vet care fee charged to the owner. If that makes sense.
Okay. Yeah, so if I have my horse seized, it's $2.50 a day for somebody to board it?
No. It's $250 a day for the initial security that gives you the right to have a hearing on whether title is forfeited. At the end of that, the cost of care calculated by the judge would include things like boarding, but under this bill, that initial fee, that initial security is only for food and for necessary vet care. It's not for boarding. It's not for the other associated expenses. Like someone on your committee asked this morning, cat litter actually costs more per day than cat food, but it doesn't cover things like cat litter.
I guess I'm still confused what the $250 goes toward.
Food.
I'm still confused a little, Lisa, what the $250 goes toward, or what it pays for.
It is a start on reimbursing the rescue, town, or shelter that is taking responsibility for the animal. It's a start on reimbursing them the food costs for the animal.
Okay, so above the $250 a day then will be everything else, whether it's vet care, any kind of special needs, any extra food, Is that right?
Yeah, and that would all be recouped, in theory, at least at the end of the day, at the end of the trial, once it's determined that the person is in fact forfeiting title through this process, the judge would say, okay, total cost of care for this horse, let's say, for the 3 months it was in care is, let's say, $7,000. You put in as a security amount, you put in $600 because you put in for the vet plus $100 towards the food. So you now owe that cost of care minus the security you put in at the end of the hearing.
Okay. Yeah. Now it's kind
It's
of
really, yeah, it's
blown
about
away by the
timing.
250, thinking you can't even have it at home for 250 a day.
That's probably part of the problem with coming up with just these gloss numbers. A horse versus a goat versus a beef cattle. Those are all going to be very different expenses, and trying to come up
Right.
with one number for this purpose.
Because the board of horses, what, $600, $700, $800, depending on where you go. I don't think I'm too far off.
So,
A month.
and I think in December, we'll have more accurate numbers that we'll put into place, presumably next session, right? That's how I think it's set up. Hopefully.
Exactly. I'm going to work with folks in the livestock realm, which I have to admit, my background's not in livestock. And so that's something I'm going to rely pretty heavily on other folks for. But even if you think about a dog, boarding for a dog for a day, you're going to pay $25 a day if you board your dog, low end. And we're saying $1 a day for food. So there's that huge gap once you put in care, not just food. And that's what care and space, it becomes a much bigger number. But those are at the end of the day, because if you think about it, when you all were talking about this bill initially, you don't want the bar to someone exercising their right to a hearing to be so high that they lose their rights simply because they can't put in that amount. And I have 6 dogs, for example. If my dogs are living with me, I'm just paying their food on an everyday basis. If they're seized and being held by somebody, and you're telling me I have to put boarding costs in before we even establish that they were lawfully seized, that's a real hardship, because 6 dogs at $25 a day is not what I pay to have them here at my house.
Okay, so other questions for Lisa? So I'm getting the sense that we're okay to probably concur with this amendment. Am I misreading the room? But I seem to think that that's where we seem to be.
Yeah, I mean, I don't know, I don't know if Lisa has any thoughts. I'm not gonna fight this at all, but like, I still just question the wisdom of setting things in statute that we want. I hear what you're saying, like, we have this way to adjust things annually. We don't do that. So I'm curious about why the Senate Finance says we're moving away from setting things in rule versus statute, but it's a conversation for another time.
Ways and Means, that was their prerogative to look at that, and they voted 11-0. So, yes, but
And could the recommendation be made, you said that when you go back with the rates, that you also ask for it to be tied to some kind of price index? Or like, not a price index, but a inflationary index? Because we definitely have some things in statute that are tied to inflationary.
and that is for next session and for
Right.
Ways and Means and Finance.
Right, but if he writes her report.
Yeah.
I mean, we have so many examples of when we set fees in statute and then we adjust the laws that impact the fees, and then the fees are dramatic, like then the revenue from the fees dramatically, is reduced. And I'm not saying that will happen in this case, but I'm just not sure about the wisdom of that. So
Even the $2 per license, I don't know how long it's been that. And I don't know if other municipalities start licensing cats and guinea pigs, right, that there will be something that the legislature looks at to have a surcharge or whatever. go to,
Not this bill, and I will.
no, but again, in the report over the course of the summer.
I will take a motion to concur with the Senate proposal of amendment. So is there a second?
Second.
And this is a straw poll. Coach, are you with us? So all those in
Yes.
favor, please say aye.
Aye.
Anybody opposed? 11-0.
All right.
Barbara's gonna vote it. I will let, they're gonna take off notes count as well. Patty okayed it.
Mr. Chair,
Yes, yes, it's true.
I'd just like to congratulate Lisa on her work. Since we've started this endeavor, and don't sell yourself short.
Yeah, thank you very much, Lisa. I really appreciate all your work on this. Really, I think we've come out with a very good bill. So thank you very much for your work.
Long road.
And long road. So we're gonna go.
And she is a good investigator too.
So we are adjourned until further notice. At some point, we may be getting back to 193. But right now, we're just going to adjourn until further notice, and we'll let the speaker know that we're ready to go on 578. So